Society. No problem. So for those of you that were being recorded, so this can go up on the Law Society website for those who aren't able to participate today. My name is Glenn Rutland, and I am the past chair of the Discipline Committee for the Law Society. Tracy Carroll is the new chair who took over for this year. But I agreed to do the presentation on the discipline process. I've often, when talking to members about this, distracted by a puppy. When talking to members about this, I've often said, like, you know, with the discipline process, it's often what I refer to this presentation as is what to expect when you're expecting the worst, particularly for people who haven't had a discipline complaint against them before. Not really, if you're not familiar with the process, it can be a really disconcerting experience. And I'll talk a little bit about that. And the goal of this is to actually fully explain the process so that if, or more likely when, you are the subject of a discipline complaint, you'll be aware of what the process is, what your obligations are, and the process will be a bit easier for everyone involved. So starting off, no one likes the word discipline. It actually starts from, I think, what is really a negative place. And I often, when talking to people about this, reframe the idea of discipline in terms of the regulatory framework. Self-regulation, which the lawyers currently do have, is a privilege that's not afforded to all professions. A number of the professions here in the Northwest Territories are not self-regulated. They're regulated by the government. And it's a privilege that we have, and we need it. It's one that we need to take seriously if we want to be able to maintain that. So instead of talking about necessarily disciplining lawyers, I like to think of it as the role of the Law Society. One is we regulate who can practice law in the Northwest Territories, but we also have a responsibility to regulate how people conduct themselves while they are practicing law. So this is really the regulation of how people practice. So it's so try to move away from this idea that we're necessarily disciplining people for doing something wrong, whereas it might be just how they're practicing could be done differently and is getting them into some trouble that we can hopefully get them out through this process. Now, in terms of regulating how we practice law, it's very much focused on conduct. So in the current Legal Profession Act, we have two, so the Act provides that unprofessional conduct can be subject to discipline. And how the Act is structured is there's two components to unprofessional conduct. One is conduct unbecoming a barrister and solicitor or student at law. And throughout this process, this whole process also applies to articling students. So I won't always necessarily reference that, but when we are talking about it, it does apply throughout. So in terms of conduct unbecoming a barrister or solicitor, how it's defined is on your slide there. But in practical sense, it really is conduct that gives lawyers a black eye, or conduct that hurts the public, or something that damages the reputation of lawyers. So this is where often, you know, when you talk about like conduct that might bring the profession into disrepute, is something that you would fall into this conduct unbecoming a barrister and solicitor. In the Legal Profession Act, it also refers to professional misconduct, but it doesn't actually really define what professional misconduct is. But generally, it's applied as any actions or conduct which contravenes the moral, ethical, and professional code of conduct for lawyers. So here, the starting point and the reference that we most often go to would be the Code of Professional Conduct of the Law Society of the Northwest Territories. And this is part of sort of the standard code that's been adapted a little bit in every province and territory. But generally, if we're looking at professional misconduct, we're looking at a violation of the Code of Conduct. Now, in terms of the Code of Conduct really sets out a number of principles, and then there's a number of rules, and then there's a number of commentaries, and all of that is designed to provide some context to the principles that are set out. it's important to know that the code of conduct in itself is not exhaustive. It will set out very broad principles and then provide some specific guidance around the rules and commentaries, but it doesn't cover every situation. So really what you need to think about when you're looking at the code is that it's a guide that establishes minimum standards. So it really is, it's a floor, it's not a ceiling for what is expected of conduct. So one of the challenges we have in our profession is that there will be situations that comes up that will raise ethical considerations that won't necessarily fall in some of the existing rules or commentary. And that's where a lawyer really needs to start navigating that themselves to avoid ending up in the area of professional misconduct. So it's very important to be aware of what's in the code and generally try to revisit that. I suggest doing that once a year, revisiting the code, the key principles, some of the commentaries, particularly ones that are particularly relevant to the style of practice you have. If you do find yourself in a situation where the code is not helpful, where you are faced with some sort of situation and you want to try to avoid ultimately some form of misconduct, you can reach out to the Law Society. You can reach out to senior practitioners. So other people who practice in your area who are more senior, you can look for judicial decisions on the code, decisions from other law societies. And we also have our practice advisors. So those are all opportunities where before you actually end up finding yourself in a situation where there could be some allegations of misconduct, if you're trying to figure out how to navigate that situation, you can always reach out. And that's a great way of trying to avoid ending up in the more formal process. As discipline chair, I was happy to talk about hypotheticals. If you were sort of worried about where things were going, once it starts getting too specific, then I would tend to step back. But that's another thing as well. There's a number of members of the discipline committee with a lot of experience who you could always reach out to. So that's sort of the context for the presentation. Now, the part where we start going into the actual process. So this is where, people actually start expecting the worst, particularly if you've never had a discipline complaint against you before. When you discover that a complaint has been made against you, it can bring about feelings of anxiety, fear, anger, dread, outrage, but it doesn't have to be that way. The process, we have a very established process. It's a fair process. A lot of the process is actually confidential and not public. So there's a lot of ways where there are protections as you go through this process, particularly where complaints may be unsubstantiated. So when a complaint first happens, if you're feeling any of those things, we've got a number at the end. Reach out to another lawyer, do a bit of a gut check, that kind of thing, but know there is a process. We're not going to go straight to you were wrong and now what are we going to do about it? What I hope is after sharing some of the knowledge and helping you understand the process, you won't feel these things when we actually reach out to you in the case of a complaint being made against you. And I know earlier I said if and when. It's more likely than not that you'll likely be subject to a complaint at some point in your practice. The other interesting thing that we've noticed over the last couple of years is traditionally we would see lots of complaints against lawyers in private practice. There's actually been a sharp increase in the number of complaints against lawyers who work for government. So who may be involved in files in litigation, who are involved in prosecutions. We've actually seen a growing number of complaints made against government lawyers. So I think a lot of people traditionally have felt that that's not necessarily a situation they're going to get into, because often they see the discipline process as client complaint driven, but that's actually not the case, as you'll soon see. There are 3 ways that the discipline process can kick in. And it all starts with the complaint. So the complaint can come from a third party. Like I said, people traditionally also see this as a client complaining about their lawyer. And this is the majority of the complaints we get are third-party complaints. So they will come from clients about their lawyers. People will often complain about the conduct of another lawyer involved in their matter. So it's not necessarily their lawyer, but they're complaining about the opposing lawyer. And we also have complaints from one lawyer about another lawyer. Like, so for example, if they're on file with someone else and they have concerns about the conduct of that lawyer can often file a complaint. So that's where you start seeing the bigger way that complaints can be generated, regardless of your kind of practice. The Legal Profession Act also provides that the Law Society can initiate a complaint on its own. And essentially that's if something comes to the attention of the Chair of Discipline that can form the basis of a complaint, the Chair of Discipline can initiate a complaint and investigation process. And that's something that while I was Chair of Discipline, we did do on probably about 2 or 3 occasions where there was generally some fairly public matter involving some lawyers where a complaint didn't actually come in, but just it was initiated by the chair. The other place where a complaint may be coming out from the Law Society is the audit process. So the Law Society does spot audits on lawyers in private practice. And often as a result of that, there may be issues of compliance around trust funds, compliance with the rules around client identification, file management, different things like that, that come out of that audit process that can often then lead into a complaint if it's serious enough. The third way that the discipline process can start is when a lawyer reports themselves. So this is often, for example, if a lawyer is facing, if they know something they've done would constitute unprofessional conduct, they can report themselves. Also, if a lawyer is charged, for example, with a criminal offense, there is an obligation for them to self-report to the Law Society as well. So that's another way that that can go. What's important is the Act actually requires that complaints be made in writing. And have we shut down? Okay, so we take all the complaints in writing. Often people call the Law Society and want to make a complaint. And often that's the first stage where we can do some early intervention. A majority of the calls is, I want to complain about my lawyer is not getting back to me. Rather than starting a discipline process, the Law Society can call the lawyer. And generally that will be enough to sort of get the ball rolling and get it out of the discipline process. The Law Society has actually shut down. We did have for the last year, 2 years, an online complaint system where people could go to the website and file a complaint online. The Law Society has since shut that down. And we've gone back to actual written submitted complaints. The move away from that was we saw a dramatic increase in the number of complaints. The number of complaints where really there's not a lot of substance. And talking with discipline administrators across Canada, pretty much everyone who had moved to online had seen the same dramatic spike in complaints. So the other issue with the online complaints is it doesn't provide that option for early intervention and being able to try to keep it out of the discipline process. So the executive has made that change. But if a written complaint is received, it's received by the executive director and then it's forwarded on to the chair of discipline. If the chair of discipline is in a conflict, then it would be redirected to one of the vice chairs. So generally we try to have a chair and 2 vice chairs. How we've balanced it the last few years is generally someone working for the territorial government, someone in private practice, and someone for the federal government as the chair and the 2 vice chairs, just to manage conflicts. The chair reviews that complaint and decides whether or not the complaint will be accepted. What's important to note is that in the current Legal Profession Act, the standard for accepting a complaint is very low. The only reason that it can be dismissed is that the chair has to be completely satisfied that if everything in there is true, it could not result in a finding of unprofessional conduct. If there is anything in there that could possibly result in a finding, then it has to proceed to an investigation stage. So generally, the number ones that are dismissed are quite few. And say generally, we're going to err on the side of caution and have a complaint investigated. and then see what comes out of that. Where complaints could be dismissed at this stage is if someone is complaining about their lawyer's bill, because there's nothing really in the discipline process that does that. There's the taxation of accounts process through the court, so that's generally person is redirected there. The other place where where I, at least in the past, have dismissed is what the issue is someone doesn't like the answer they got from the lawyer. There's actually nothing wrong with the response from the lawyer itself. They just don't like it. And that's not gets us into the realm of unprofessional conduct. Otherwise, generally, most investigations will be, or sorry, most allegations will be investigated. Now, if the chair accepts the complaint, the first thing that the chair does is appoints an investigator. The investigator is selected from the members of the discipline committee. And when we're looking at assigning an investigator, there's a number of different factors that go into it. Availability. We do have certain time restrictions. Ideally, we'd like to have a complaint investigated and a report back within 90 days. So a big factor is what someone's availability. Whether or not they need to have knowledge of the practice area. So in some cases, some knowledge of the practice area is relevant to the investigation. Others, it's not. And so that's something. And also looking at conflicts. Other things that we factor into this is whether or not someone's conducted investigation prior or recently. All of our discipline members are volunteers. So we try not to use them too often. If they've conducted a past investigation into the lawyer who the complaint is about, we'll often not use them. Or if they've also done an investigation into a matter from the same complainant. We've had several complainants who make repeated complaints against different lawyers, and we'll try to have a different investigator each time, just so that the respondent feels that they're getting, or either the respondent lawyer or the complainant feels like they're getting a fair, sort of fresh hearing. Now, the one thing is, if the complaint is dismissed or not accepted by the discipline chair and dismissed, the complainant is told, and the lawyer who the complaint is about is told that a complaint was received and it was dismissed. So they will find that out, and they're just advised of that in writing. If the chair has accepted the complaint, it's only after the selection of the investigator that the respondent lawyer actually finds out a complaint has been made against them. So everything up to this point, you as the responding lawyer aren't aware that this is happening. So what happens is the chair of discipline will write the complainant and will write the lawyer who is being complained of. And generally in that letter, we say, we've received, so to the complainant, we've accepted your complaint. We're going to be investigating it. This is the investigator. So we tell them who the investigator is, what the investigator's role is, and that the investigator will be in contact with them after they've reviewed the material. For the respondent lawyer, we send them a similar letter saying we've received a complaint, it's been accepted. We give them a copy of the complaint so that they are aware of what's being alleged against them. We let them know who the investigator is, what the investigator's role, and that they have 14 days from receipt of that letter to provide a written response to the investigator. And what's important is that, as is noted here, you can request an extension, and the investigator can grant you an extension. But it is important that when you get that first letter, and within those first 14 days, make contact with the investigator. If you try to turtle and try to ignore, you're just going to end up actually in more trouble as you sort of go ahead. So reach out to the investigator immediately, let them know that you've got it, let them know that you're working on a response, and keep engaged with them. Now, the other thing that we also tell the complainant, and this is important as you prepare your response, is that whatever response the lawyer provides, generally we'll share with the complainant and ask them if they have any comment on that. There are some times where and this is included in the letter. So for example, we've had an increase in people making complaints about opposing counsel. So a client, one of the opposing parties is making a complaint about the opposing counsel. So what we do say is if there is material in your response that is privileged and you need to provide that information to address the response, is to identify that, and that information will be not shared. So it's not a way for an opposing party to try to start getting at privileged information or anything like that. That is all kept privileged and redacted. But if it is relevant to the response, that's something you need to identify and share. So the investigation, so once you've been notified and this whole process of responding starts, this is the most active part of it. The most important thing to know is at this stage, it is not public. There's no public notice that there's a complaint against you, anything like that. Everyone is advised in the letters of the complaint that this process is confidential and that they're not to disclose this information. And we do that because the investigation is not a trial. There will be no determination made at this point whether or not you've actually breached the code, whether it's unprofessional conduct, whether it's conduct unbecoming. The investigator at this point doesn't make finding of facts, doesn't make any determination of guilt. All they are to look at is whether there's a reasonable prospect of conviction. So after reviewing the material from the complainant, the material from the lawyer, any other material that they may need and request during their investigation, whether or not there would be a reasonable prospect of conviction for unprofessional conduct or conduct unbecoming. They don't make a recommendation as to what should be done if there is a finding. It really is just is there a reasonable prospect of conviction? And one of the things that we do is we have a threshold guide, which is designed to help investigators make that determination. And we provide that to each investigator when they start. And as I mentioned earlier, it is a 90-day timeline. So that is actually a national standard set by the Federation of Law Societies of Canada. So that's set by the National Discipline Standards, and we report against that each year. Across Canada, people are having challenges meeting that time frame, mainly with an increased number of complaints, the limited resources to do it, and also generally parties seeking extensions to be able to respond fully. Just on that note about the privileged information, you're not able to refuse to respond on the basis of solicitor-client privilege, but you may want to seek some legal advice if you have questions or concerns related to privilege. Now, as I said, all investigators are encouraged to have their investigation completed within 90 days. There's also some investigations that are just more complex that will require more than 90 days. And what we do is the member and the complainant are advised. Generally, after that 90 days, additional time is required, and then generally we do fairly regular updates after that. And the executive director does that follow-up and monitoring on the timeframes.
Just a quick question, Glenn, on the issue of not being able to refuse a question on the grounds of solicitor-client privilege. Is that in the Act, or where does that come from?
I believe it's in the Act.
Okay. I suppose it would have to be.
Yeah. I can't recall the section off the top of my head.
Okay. Yeah, I don't mean to put you on the spot, but
yeah.
Okay.
So during the investigation, you could have multiple contact back and forth with the investigator. You may only have one contact with them where you provide the information. There's not a very clear standard for it. We have had in the last year on judicial review a written decision that essentially says there is no, the Act does not create an obligation that there has to be interviews conducted, that if a matter can be reasonably dealt with on written submissions, it can be dealt with as written submissions. We've also had a judicial review that says, well, you should have gone out and gotten more and talked to some people. So there's a bit of a conflict there. So it's really context specific. So if you feel that there would be some value or some merit in having a conversation with the investigator, reach out to them, let them know that the investigator will make those determinations, but generally their goal is to try to do the most thorough investigation possible. So most of our investigators would be open to having those conversations. So the investigator ultimately puts together a report, and that report will go to the chair of the discipline committee. That report states whether or not the investigator has concluded there's a reasonable prospect of conviction for unprofessional conduct. And at this stage, the chair will make a determination as to whether or not they accept the recommendation. So if the chair reviews the report and determines, okay, I accept the recommendation that there is not a reasonable prospect of conviction, or that there is a reasonable prospect of conviction. And depending upon what the chair accepts in terms of that recommendation, determines the next steps. It's important to note that at this stage, particularly if you're a volunteer member of the discipline committee, usually what we do is we ask you to provide a draft of your report to the chair of the discipline committee for finalized. That's not for us to be able to go in and muck around with your findings or your conclusions or anything like that. But it's really for us to be able to take a look at, to say, is everything in there? It's a second set of eyes to say, I see your conclusion, but there's some gaps missing in how you got there. So it's really just a high level sort of review, just to make sure that we're getting the information we need to be able to make that determination. We're not going to say you should come to a different conclusion. We won't do that. Ultimately, if we decide to do that, we'll do that after it's received, but we won't ask you to change your report or your recommendation. So if the investigator determines there's no reasonable prospect of conviction, the chair has to either accept or reject that determination. If the chair accepts it, so at this point you've had the investigator say there's no reasonable prospect of conviction, you've had the chair say there's no reasonable prospect of conviction, we then bring in one of the non-lawyer members of the discipline committee. So we have 3 to 4 members who are lay members of the discipline committee, who then what we do is we send the report to them. They review the report and they have to agree with the recommendation. So if they also agree that there's no reasonable prospect of conviction, then the complaint is dismissed. And that's just to make sure that there is someone else, more representing the public perspective, agreeing with the determination. When it's dismissed is essentially a letter is sent to the complainant, and a letter is sent to you as the responding lawyer. A copy of the report, the investigation report, is provided to you and provided to the complainant. And they will, and we note in the letter that goes to the complainant that the report and the conclusion have been reviewed by a non-lawyer, and that non-lawyer agrees with the conclusion. So it sets out the fact that 3 different people have reviewed, like the investigator and 2 other people have reviewed this and all agree with that conclusion. And then at that point, the matter is closed. There's nothing on your record, anything like that. This whole process has been confidential, and we just move on. Now, often there can be sort of a middle ground where there's not a reasonable prospect of conviction, but there's some issues that have been revealed as a part of this investigation. And so this may be where there's conduct that is contrary to the interests of the profession or to the interests of the public. And the language that is used in the Act is that it calls for advice and direction. So this is where it may not rise to the level of misconduct, but what's revealed is there are file management issues in someone's practice, where there might be some issues where someone's maybe getting over their head in terms of if they're early in their practice. So what this does is that this allows either the chair of discipline themselves or another member of the discipline committee to have a conversation with the member in question. So ultimately, the matter will still be, it still doesn't proceed to the formal sort of sole inquirer because there's no reasonable prospect of conviction, but it's going to benefit everyone involved that there be some discussion. So this can often take the place as mentoring. So someone will have a conversation with a lawyer about their practice techniques, different things like that. Also, if one of the issues with the discipline process is that for complainants, this process doesn't achieve what most complainants want. There are very few, there are a couple of complaints where people are making a complaint because they want a lawyer punished, right? 9 times out of 10, that's not what someone wants something to happen. Either something didn't happen with their file, their lawyer hasn't called them back, things haven't moved forward, they're unhappy with something. The discipline process, they don't have real standing in the discipline process. Our entire process, once we get past this investigation stage, is focused on the lawyer and the lawyer's conduct. So the chair can also, if there is some of these sort of other issues, refer the process to a mediated resolution process. And we can do that sort of throughout the process. So one complaint, really, a phone call to the lawyer, some action taken on a file, the clients got the outcome that they wanted, and they were more than happy to just leave it at that. So that's another way that we can sort of, get out of a formal discipline process, but still actually deal with issues of concern, but actually get better outcomes for clients and the outcomes that they're looking for, versus, someone just, a lawyer may be, punished, could be suspended for a couple months, maybe pay a fine, pay costs. That's not going to do anything for the client. Ultimately, it may protect clients in the future, but it's not going to protect or resolve it for that client. And certainly in the new act as well, there's more room for those kind of solutions and interventions. It's a bit more limited in the current act, but we have been able to do some diversions through that way. The other option that we have is if the investigator feels that there is a reasonable prospect of conviction, but again, a mediated resolution process is appropriate, the chair can refer that. So one of the things that we ask on our written complaint form is if the client is open to a mediated resolution process. And if that's something that they're open to, then that's something we may want to explore. Again, this is going to depend on situation and the conduct, and most likely this is where it's related to a client outcome. There's really, if it is generally sort of egregious behavior, if it is things related to trust funds, different things like that, that's not a process we're going to go down. If the investigator believes there is a reasonable prospect of conviction and the discipline chair accepts that recommendation and agrees, then this is the process where there's a change in our entire process. We're moving away from the investigative process and we're going into an adjudicative process. So what will happen is at this point, the chair will need to make a determination as to whether or not the matter goes before a sole inquirer or whether it goes to a committee of inquiry. And I'll speak a little bit more about that in a minute and what the different outcomes are, because that changes the outcome. A sole inquirer doesn't have the authority to recommend disbarment, which a committee of inquiry does. So that's probably the single biggest decision-making factor as to which approach this will go. And it's important to note the chair makes this determination, not the investigator. The investigator just, is there a reasonable prospect of conviction or not? As the discipline chair can consult with the vice chairs before making a direction or a referral or a designation or establishing a committee of inquiry. But if that's done, then that vice chair cannot be involved in any other further way. And if it is going to be referred to a committee of inquiry, the chair has to notify the executive, the respondent, the complainant, and any other person who may have a legitimate interest in the matter that it is going to a committee of inquiry. And the primary reason for that is the committee of inquiry process it's more formal, it's going to be longer, it has more serious ramifications, and will have more costs to the Law Society itself. And usually at this point, we engage counsel to prepare a formal citation. So this will be the actual charge that is being laid, or the formal charge being laid against the lawyer that they will be making a determination on. So again, a sole inquirer is appointed from among the members of the discipline committee. It is exactly what it sounds like. It is one person who is appointed to conduct an inquiry into the matter and make a determination. We will go this route if there is a conviction. It's not going to result in disbarment, suspension, or a fine greater than $2,000. So this is really for more minor offenses, and the public interest does not require a committee of inquiry. So this is what the chair of discipline will weigh in determining whether or not a sole inquirer is the appropriate one. More often than not, we've appointed sole inquirers than committee of inquiries. But the other option is a committee of inquiry. If a committee of inquiry is appointed, it's 3 people, all members of the discipline committee, 2 members who are lawyers, and then one of our layperson members, one of our non-lawyer members also goes on. Right now, as part of the national discipline standards, there is a requirement to offer people involved at this level adjudication training. So we have about 5 members of the discipline committee who have done or are undergoing some form of adjudication training, including one of our lay members. So that if we are required to put together a committee of inquiry, we have people with the skills and experience to do it. Unlike a sole inquirer, disbarment is a potential option if for a matter that goes to a committee of inquiry, suspension, or a fine exceeding $2,000, or the public interest requires that it be before a committee of inquiry. Now, regardless of whether it's a sole inquiry or a committee of inquiry, there are a few things that are done. So the chair can withdraw the matter from the inquiry process if the inquiry is not started. So while someone is being appointed, but the actual formal inquiry process hasn't started, it can be withdrawn, but it has to be on notice to the parties and with reasons. I'm not familiar with a situation where that's come up, but there are probably some situations where it would. A sole inquirer. So if the sole inquirer is appointed, they are conducting their inquiry, they're getting deeper into the issue, they're going along, and they become of the opinion that if the member was found guilty before a committee of inquiry, they could be disbarred, suspended, or the public interest requires it. A sole inquirer can just discontinue, contact the chair, and say a committee of inquiry needs to be appointed. So that's important to note, that even if you end up in the sole inquirer process, that doesn't necessarily say disbarment is off the table or suspension, because there is the possibility where, as they get deeper into the matter, that changes. The whole inquiry process is conducted in accordance with rules of natural justice, not bound by the rules of evidence applicable to judicial proceedings. And they do have powers to summon a respondent or a complainant as a witness, produce materials, issue notices, and ascertain facts in any way necessary, and make findings. So if a sole inquirer finds there has been professional misconduct, the member officially receives a reprimand, and the sole inquirer, in addition to a reprimand, can impose practice conditions. So if it is a practice-related issue, they can impose conditions on the member's practice. They can order the payment of a fine, and they can also order that the member pay the costs associated with the inquiry. One of the things, the cost of the inquiry, if anyone's familiar with discipline decisions or monitors some of them, that is often the most significant penalty that will come out of this. The fine may actually be negligible. The reprimand, yes, it is a public reprimand, is on your record, but often the members asked to pay the cost of the inquiry, and those can be substantial. So it's important when you're considering in the inquiry process, if you're represented by counsel, the Law Society will most likely be represented by counsel. One of the things that you may want to do is consider whether or not you can proceed with an agreed statement of facts. You know, if that's something that you can do, that isn't prejudicial to you, that's an important first step because it actually helps reduce the cost of the inquiry, which ultimately, if you are found guilty and responsible for costs, that's something where there is some, I don't want to say it's an incentive to do that, but it's a good practice to consider whether or not there can be an agreed statement of facts so that the inquiry is solely focused on the actual issues in question and not trying to spend a lot of time determining things that really shouldn't be in question. In terms of a committee of inquiry, they can order that a member be struck from the roll. So this is effectively disbarment. They can order suspension for a period of time, or they can reprimand the member, same as a sole inquirer, and they can impose practice conditions. The fine, if it goes to a committee of inquiry, can be up to $10,000. And again, they can order the member to pay costs of the inquiry. Now, if it goes to either sole inquiry or committee of inquiry, and the member is found not guilty of professional misconduct or unprofessional conduct, that member can actually apply to the executive for an order that the Law Society pays some of all of their costs, some or all of their costs associated with the inquiry. So the cost award doesn't just necessarily work against you in terms of if you are found guilty, but there is the possibility where you can apply. If you're found not guilty, you can apply to the executive to get some of those costs back, which is part of the reason why the executive is not involved in any of the decision making associated with this. It's important to note it is discretionary. So obviously the executive would need to consider a number of factors, consider your submissions, different things like that. But there is that option available to members. And that gets us to that end of that process, but there's a couple other discipline things that I wanted to touch on. One of the challenging issues over the last couple of years really has been discipline and mobility. If you are a member of the Law Society here and a member of another law society, it applies across the board. So we need to have some sort of jurisdiction over a member. So one of the challenges we have is like with dated complaints where we no longer have jurisdiction, we then have to look at, is this more appropriate that it goes to whoever is regulating the member now? Because the way the act is structured, we don't actually have jurisdiction over someone who isn't a member. But one of the other things that happens under mobility is the chair, under the act, the chair can suspend a lawyer here and their membership in the NWT if they have been suspended pending an investigation in another jurisdiction, or if they've been suspended as a result of disciplinary proceedings. So if we have someone who's a member in Alberta and also here, and they are suspended pending investigation in Alberta, I have, or not me anymore, but the chair of discipline can choose to suspend that person here. And then if they are suspended as a result of a disciplinary process, generally we mirror the exact same process here. So that they would have the exact same suspension here, just to ensure that that's consistent across the board. We wouldn't go through a whole new process. We would just respect the suspension from another jurisdiction. Unauthorized practice is another area that the discipline committee deals with that many people don't realize. So occasionally we receive reports, or more often or not complaints about lawyers from other jurisdictions who are practicing in the NWT. 90% of the time, this is just someone who's misunderstood the mobility agreement, is not live to the different territorial mobility agreement. The first usually thing we do is a letter goes from the Law Society pointing out the requirements, noting that they're a member, and generally that resolves the matter. We either get a response back that they're not practicing law and they provide us information as to how they're not, or there is a pretty fast mea culpa and they're submitting their application for a restricted appearance certificate or membership. That's literally most of them are resolved that way. Occasionally, we also receive reports or complaints of non-lawyers practicing law in the Northwest Territories. Generally, again, that's resolved by a letter. So we will write to the person, we share with them what the practice of law definition is in the Act, and that if they're doing any of that and not a lawyer and not registered here, they can be subject to penalty, and that generally clarifies any issues. We either get a response back or they change the behavior. One of the things that members should be aware of is that if members are practicing under restricted appearance certificates, those are on the website. So you can search a lawyer and it will tell you whether or not they have a valid RAC or whether they're a valid member. So that's one way before making a report of unauthorized practice. It's a quick and easy way to check. There is also provisions in the Legal Profession Act for automatic suspension of members. So a member who's sentenced to a term of imprisonment will automatically be suspended during the time the member is imprisoned, or is serving a conditional or intermittent sentence of imprisonment, and during any period of parole. So that's important. That's part of that self-reporting. If someone faces criminal charges, they self-report. We then monitor that process, because ultimately, if they're convicted and face one of these penalties, they would be automatically suspended. We don't go through a process or anything like that. It's just an automatic suspension. So those are a couple other things just to note that are discipline related, but not necessarily part of the formal process. My pitch, going back to this whole concept of self-regulation, it is on all of us as members of the profession to bear this responsibility. And we need you to be able to do it. So if you're not a member of the discipline committee, and if you're on the executive, you can't be on the discipline committee, but otherwise generally you can be on the discipline committee. If you're not on the discipline committee, I do ask you to consider joining. The more people we have on the discipline committee, the less work it is for everyone involved, because we have a wider pool of people to select from. It also helps us manage conflicts better, different things like that. If you've been in practice and resident in the Northwest Territories for 3 years, you can be on the discipline committee. If you are a non-resident member, you've had to have been a non-resident member for 5 years in the Northwest Territories before you can be on the discipline committee. Another one is you must not have been found guilty of unprofessional conduct within the last 5 years. So that's only if it's gone through the actual inquiry process. And in terms of membership on the committee, you can be involved in investigations. You can be called on to provide advice and direction, or you can ultimately be a solo inquirer or on a committee of inquiry. We're looking at doing new investigations training for the discipline committee members probably in the upcoming year. So if you are interested, now is a good time to get on the committee because we will be doing that. One of the other things that Tracy has changed now is that when we have a number of resources that we send to investigators. When you're appointed as investigator, we have a sample report, we have the threshold guide, we have excerpts from the rules, from the Act that we provide to you. We also did a CPD on conducting discipline investigations. It was myself, Rowan Brown, and Sheila McPherson. And that's available on the YouTube site. So we're also now sending that link to people doing investigations as well. So if you're looking for some advice on investigations, that's another way of doing that. And then we also are providing for a smaller group of members on the discipline committee access to adjudicator training through Alberta as well. So there is some benefit going on the discipline committee, but it also helps fulfill your professional responsibilities and helps us manage the workload because the workload has gone up the last couple of years. Finally, if you are the subject of a complaint and you've heard from the discipline chair that a complaint has been made against you, don't turtle, don't ostrich, talk to, another lawyer that you trust. There are lawyers who their area of practice is discipline-related matters. So you can get some professional advice if you want to. Talk to other lawyers that you work with, talk to other lawyers you may know socially. You can also access the lawyer and family assistance plan. It's the telephone number's there, it's 24 hours. So it's not worth getting super stressed about this. And I know that's easy for me to say, being at this end of the discipline process. But it's a fair process. It's going to go through, we'll get to it. And quite often, the majority of the discipline things, even if they end up, like I said, disbarment is rare. Even suspension here is rare. Often it is usually, if there are issues, they are relatively minor and we can address it. We don't have the large, trust fund matters where we have like huge matters like theft from trust funds and things like that. We're very fortunate with the kind of discipline issues we've had to deal with. So yeah, don't stress, but if you are stressed, reach out to someone. And I'm also now, I'm past chair of discipline. More likely than not, I'm probably not going to be involved in a complaint that's against you. Call me. I'm more than happy to talk you through it, or even talk you down, at least, if you do end up with a complaint against you. I don't know if there's any questions. I see there's a chat.
There is, and I've been looking at it in there. One that just popped up.
How long does the notification member says notices? I don't know the answer to that. Heather, we'll find out, and then we'll let people know.
Oh, how long is it included on the website? I think
Included forever.
forever,
So
because if it was sanctionable, then a member of the public, if they're searching a lawyer, should be able to access that. So yes, forever.
there we go. And that's only where it's gone out of the investigation process and to the inquiry process.
Sanctions.
Yeah.
One.
All right. Any other questions? Austin?
So investigators and then people who are on panels, you'll ask, but I gather you can't insist, but you can ask. So, because what kind of couples with it is, we've all got our, we're on the committee because we volunteered, therefore we're accepting some responsibility. But it's not an easy business to investigate, and especially if you're going to be asked to hear a case. That's not only it can be challenging, just the experience, but also just being confident that you know how to do it. So I guess you kind of ask and probably try and persuade, but there's a point there where you just have to accept that the person doesn't want to do it. Is that the way it goes?
Yeah. So my usual practice is what I would do is I would reach out to a member of the discipline committee and just say, I've received a complaint. This is the name of the complainant. This is the name of the responding lawyer. And that's all the information they would get at the beginning. And just say, would you have availability and would you have a conflict, right? And that's the first, because I'll say usually we want to get this resolved in the next 90 days. And so often if someone replies back and says, I don't have availability or I have a conflict, it ends there. If someone's like, I'm available, I don't have a conflict, then usually what we'll do is we'll say, okay, here's a little more detail.
Need a copy of the
Complaint, yeah. And then they can take a look at it. And then if something in that flags a level of discomfort, then, that's why we don't, until we actually have the person fully confirmed, we don't send out any notices to anyone. So often we've had to go through different investigators because like someone may be available, may not have a conflict, but then as they actually get the complaint, they see there's other people involved where there may be a potential conflict, or they just see that the actual issue is something that they're not comfortable with. They may not have the knowledge for different things like that. So then we go on. And the one thing, and I imagine there's a number of them I can see on here as well. I'm also very grateful for our non-resident members of the Law Society here who are members of the Discipline Committee. Thank you. with such a small bar here, we run into a lot of issues with conflicts. And usually what it is, where there's been a relatively high conflict matter, that tends to generate a lot more complaints. So it's tend to already be a public matter in the north that's had at least more than usually 1 or 2, 3, 4 lawyers involved. Often we need to go to our non-resident members because they're the only people we could actually look to do the investigation. And at times where we've had matters that are just very complex or just involve too large of a group of people, we have actually used staff investigators from the Law Society of Alberta to conduct investigations for us as well. So if we truly run into an issue where we can't find someone, we'll do that. And we have some members have made recommendations. I've had some discussions with the executive as well about how, for example, conducting some of these investigations or different things like that could actually start counting towards CPD hours and different things like that as well. Right? Because particularly the issues that it's looking at, it's as much of a learning opportunity for the investigator as it is for the members involved. So that's something I know I think the executive is looking at.
Absolutely investigated.
So
It's a lot of it.
yeah, and it's recognizing it's a lot of difficult work, and it's also why you know, you can only be chair of discipline for so long before you have to become the past chair, because it's not fun. Any other questions?
Yeah, maybe a couple more if I don't want to hold everybody. One comes out of what you talked about here, because I didn't know about it. Another is one just relates back to an investigation I did a number of years ago. So first one, which you were talking about earlier, is people who are repeat complainers. And and I remember this way back in my Ontario days, there were those people out there who were just professional litigants. And, you know, the courts found that sort of thing very troublesome. So if you're experiencing that, is there anything that the committee can kind of do where you're starting to recognize this person's showing up over and over and over again complaining, and he's putting council to a whole lot of trouble to have to face this because you can't let it go until it's all done? Is there anything that committee does with these kind of situations?
We do have a vexatious complainant policy that the Law Society has adopted that sets out. So it's not even necessarily, it can either be frequency or it could be the complainant's conduct during the process, where we can go through a process and ultimately seek to have them declared vexatious, where they would then actually need permission before they can actually file complaints or different things like that. But yeah, I know that is a growing issue, and it's something we're talking about with other jurisdictions as well. And I think the discipline administrators across Canada are trying to figure out ways of dealing with that, because it's a problem in every jurisdiction.
Okay, all right. Yeah, interesting to know. Yeah. Now, the other one, Glenn, that I want to ask about, and I think I actually did raise this a few years back. There was one investigation I did where it ended up being a lot of work. I actually kind of had to go and get into the law books a little bit, just from the late nature of the way this came together. So I made my recommendation. I had to weigh what I read, and I just, you know, I just didn't like what I saw going on there. So I made my recommendation, and I never did know where it went. But I think I kind of know, but I never did pursue it to find out. You know, as an investigator, you like to know after you put your time in making a recommendation, what did the committee think about what I did?
And I think our process has changed a bit since then, because one of the things we do at the end is we send a letter to the complainant, we send a letter to the respondent, and we send a letter to the investigator. So the letter to the investigator essentially says whether or not we've accepted their recommendation. So the chair has reviewed your report, has accepted your recommendation. And so we sort of close the loop that way. And then if if it goes on to a public process,
Mhm.
then that process is public. If it goes on to a less formal process, it's not necessarily that, but every investigator will know whether or not the chair has accepted or not their recommendation. So. Perfect. All right, well, thank you, everyone. And hopefully you all answer my call, join the discipline committee if you're not already a member. And seriously though, if you're ever in a situation or anything like that, feel free to reach out to me. I'm more than happy to talk you through it.
Glenn, it's Don Large. I have one
Yeah.
quick question. If there's a finding against the member, eventually it gets posted on the CanLee website. How long does the Law Society keep those decisions there?
So I believe that we need to have any sanctionable conduct or anything that was made public available to the public as long as that individual is an active member of the society.
So is it on indefinitely? Is that the answer?
As long as you're a practicing active member, yes, it's
Okay, thank you.
All right, any other questions? Nice hearing from you, Don.
Yeah, thank you for that.
All right, awesome. Well, thank you very much, everyone, and congratulations on your ethics hours. Renewals are coming.
They're here.
All right, thank you, everyone.
Thank you.